we'll talk about indeterminate sentence law. And as we talk about indeterminate sentence law, we have to discuss mitigating and aggravating circumstance. So after indeterminate sentence law, that means the person will serve sentence, and so we will include that topic of service of sentence. All right, so in the context of, this is what we will discuss, and this one. All right. So we'll start with indeterminate sentence law. Indeterminate sentence law is found in Act 4103, Section 1. It says, in imposing a prison sentence for an offense punished by the revised penal code, the court shall sentence the accused to an indeterminate sentence, all right, the maximum term of which shall be that which, in view of the circumstances, aggravating, mitigating, could be imposed under the rules. That's the maximum term, and a minimum of which shall be within the range of penalty next lower to that prescribed by the code. All right, so take note, without the revised penal code, the penalty is this one, imposed on a person committing a crime. Without the indeterminate sentence law, the revised penal code says, figure out the mitigating and aggravating circumstances and impose the penalty, which could be impose the penalty as prescribed by the revised penal code. Now, but because of 1403, the indeterminate sentence law, the law says, but you can provide a minimum period which shall be within the range of penalty next lower to that prescribed by the code. All right, so those are your magic words. Take note, we'll give an example. This is how it looks like. The revised penal code will impose a penalty. Take note, all penalties in the revised penal code except for indivisible penalties, which is death and reclusion perpetua. You have to see it in the context of a minimum, medium, and maximum period. Example, if you look at Article 76, homicide. Homicide is the penalty is reclusion temporal. That's 12 years and 1 day to 20 years. Note, if somebody is convicted, that person will definitely not be in prison for 12 years and 1 day up to 20 years. Because under the revised penal code, the judge will have to figure out if it is in the medium period, 14 years, 8 months, 1 day, or in the minimum period, if there's a mitigating circumstance, or if there's an aggravating circumstance, a generic aggravating circumstance, which will cause the penalty to be imposed in the maximum period. So that is what the judge will do without the indeterminate sentence law. But because the indeterminate sentence law is there, after the judge sets the penalty, figures out if it is minimum, medium, or maximum, then the judge will also have to impose at a minimum period, which shall be penalty next lower to that prescribed. Say, for example, because the person committed homicide and the penalty is imposed in the medium period, the penalty next, the minimum penalty is there within the range next lower to that prescribed by the code. So reclusion temporal, it will be prisión mayor. All right, you find this in Article 76 of the revised penal code. So what happens? What's so nice about having a minimum period? What's so nice about that is after you serve the minimum period, then the indeterminate sentence law says you are eligible for parole. So rather than serving 14 years, 8 months, 1 day to 17 years, after you've served 8 years and 1 day to the minimum period, you can ask the parole board, and this is established in the indeterminate sentence law. You can ask them to evaluate and determine if you can be granted parole, meaning you can go out of jail. All right. Take note. It's this 1401 is so nice, no? But the indeterminate sentence law cannot be applicable to if the penalty is death penalty or life imprisonment. Take note. There's a Supreme Court circuit memorandum that says life imprisonment, you include reclusion perpetua if you are convicted of treason, conspiracy, misprision of treason, rebellion, espionage, piracy, habitual delinquents, escape, evaded service of sentence, granted conditional pardon by the president, violated the pardon, alright, and if the imprisonment term does not exceed 1 year. So if your imprisonment term is 1 year, there is no minimum period to that. That is indeterminate sentence law. Alright, so now you figured out already. Say for example that person is found liable for homicide, guilty of homicide. This is the penalty, let's say in the minimum period. Yeah. So after that time, person will serve the sentence. So we go to this topic of serving sentence. How is sentence served? If you look at Article 70 of the Revised Penal Code, it says, you see these two words, simultaneous and successive. And these provisions, if you look at Article 70, have been clarified by jurisprudence. Article 70 says, serve penalties simultaneously if the penalties will so permit. Take note, according to this habeas corpus, the Supreme Court decision of habeas corpus of Pete Lagaran, the simultaneous service of penalties will refer to accessory penalties. Article 70 further provides, if simultaneous service of penalties will not permit, then it shall be a successive service of penalties. And according to this jurisprudence, when the law says successive service, service of penalties, this means the deprivation of liberty or jail time. All right. Now, also in Article 70, we see the threefold rule. It says, the maximum duration of a convict's sentence shall not be more than threefold of the length of time corresponding to the most severe of the penalties imposed upon him, but the maximum period shall in no case exceed 40 years. And perpetual penalty shall be computed at 30 years. Take note again, just so you will not be confused. Although Article 70 mentions perpetual penalties, life imprisonment or reclusion perpetua will not be persons who have been found guilty of a crime, the penalty of which is a life imprisonment or reclusion perpetua, cannot apply for, cannot enjoy the benefits of the indeterminate sentence law. Just wanted to make that clear, because you'll see again, you'll see it here. In Article 70, perpetual penalties are computed at 30 years. All right. Now, let's try to get these things in perspective. Let's talk about a person who killed 3 people. Take note, that person killed 3 people. Make sure that the killing is not a complex crime. So if that person killed 3 people, maybe imagine a samurai warrior, pulls out a sword, stabs person 1, turns around, stabs person 2, somebody's there, stabs person 3. 3 killings. Take note, there are 3 individual stabs. It is not a complex crime. We'll describe complex crimes in a bit in the next videos. The effect is, since it's not a complex crime, there will be 3 penalties for the 3 killings. Alright, so that person is found guilty for 3 killings. Say for example, there's a mitigating circumstance. Alright, so it's 12 years and 1 day, 14 months. So that's what the judge figured out, determined. Alright, now because of the indeterminate sentence law, a minimum sentence must be included. And when the minimum sentence has been served, then there can be a determination if the person can be subject to parole. But take note, this person killed 3 people. So, shall the penalties of deprivation of liberty after 6 years and 1 day to 8 years of imprisonment, can that person say, okay, look, I already did 6 years and 1 day to 8 years. I'm eligible for parole because I served the 3 penalties simultaneously. Is that possible? Definitely not. Huh? Take note, simultaneous service of penalties will only refer to accessory penalties. Imprisonment terms or the deprivation of liberty penalty shall be successive. So that person who killed three people will have to serve 6, 12, 18 years at a minimum before we can talk about parole. Now, take note, the threefold rule will say the maximum duration of a convict sentence shall not be more than 3 times. All right, the length of time corresponding to the most severe of penalties. So this one. So 14 years. So that is so for example, a person is just for example, so we can demonstrate this threefold rule. Say for example, a person is convicted of a crime, say 6 years, no? 6 years, and that person committed four separate acts that are punished 6 years, for example. Now, that person cannot serve more than 3 times 6 years. So just to 18 years, not 24 years. That's what the threefold rule says. But in no case it shall not exceed 40 years. So that's it for this indeterminate sentence law. When we connect it to mitigating, aggravating circumstance and the service of sentence.